Recording in progress. Recording stopped.
Members, morning. DG Pillay, can we test the system, please? Mr. Salamiacha. Morning, Ms. Pillay. Can you also test your audio, Ms. Pillay? I can see the document, but can you also test your audio if it's fine? You can remove it for now. I see you've unmuted, but I can't seem to hear you. I don't know if anyone else in the meeting can hear you.
I can't hear her. Her mic is not green when it goes on, so that might be the problem. I don't know if it's a connectivity issue.
Morning, DM. I was worried because I thought I maybe I'm not audible myself. Thank you for that.
No,
Ms.
you're
Pillay.
audible.
Okay, Ms. Pillay, do you mind quickly trying to get another gadget, Mr. Sebelemecha or your IT to assist you with your audio, because we can't hear you in the meeting. I can see you've unmuted yourself. Morning, Mr. Semelemecha.
Morning.
Yes, can you assist leadership? If you are in one place with Miss Pillay, I don't know if she can hear us. I'm really not sure.
I'll give her a call. We're not in the same place. I'll give her a call.
Yeah, I've also given you hosting, sharing rights to assist.
Yeah. Sia, I've given her a call. She's going to try and join from another device.
Yes, DM, I can see she has just joined with another device. There's two Miss Pillays here. I'm also giving that device the sharing rights. Miss Pillay?
Sia, can I, good morning, can you hear me now?
Yes, we're quite clear. Can you share from that? I'm also given that one.
No, I'm not going to be able to share. I'm joining from a phone. Can I request that CXC be given sharing rights? He has the document.
Yes,
he's online as well.
Yes, I've asked him to share. Mr. Sebelemecha, can you go ahead, leadership, please?
Yes, I'm gonna do that. I would normally struggle with the laptop as well, but I'm gonna try log in from the laptop.
Kelly, you were sharing fine on your original device. Can't you share on that device and speak through the other one?
Okay, I'm going to try and do that.
Yes. Thank you for that advice, TM.
Sia, can you?
Whoever is with you or the laptop, can you mute the laptop? Then you can, because it's going to give us echo. Miss Pillay?
It looks like my sound is now working on the laptop. So is that fine? Can you hear me?
You are quite clear. Can you share from that one?
Recording in progress.
You may share, Ms. Pillay, from that one to test quickly before we start. Yep, we can see it. It's quite clear. I'm sure the audio is also fine.
Can
We
you
remove
start?
it.
Good morning to everybody. Welcome, Deputy Minister John Murphy and your
Good
team.
morning, Chair.
Thank you very much. Members, before we proceed, can we just deal with some few issues for next week, so that we're able to give guidance to the administration. Next week, we will be doing interviews for the South African Human Rights Commission. But now, when we approached programming for our bills to be debated, the bills that we passed last week, we requested this week, but the program is full. So they could not accommodate us today and tomorrow. We have only been accommodated on the 14th. So on the 14th, we will debate all the three bills from 2 o'clock. That gives us a bit of a challenge because we were going to meet from 9 and proceed after 2. So which means that is the first option. The first option will be to take the candidates that are supposed to appear on Tuesday, and we load them on Wednesday instead of finishing at 3. So we might finish at around 6 or 6:30 on Wednesday. That is the first option. The second option will be to go to the House. After we have debated our bills, we come back and finish the remainder of the candidates, which means we'll start in the morning, break at 2 or at 1 for lunch, and then go to the House at 2. Then after the debates, then we come back and we conclude the other candidates. We thought that it would be important to bring this to your attention so that we can get a guidance as to whether we should proceed on Tuesday with all the candidates, or we take the remainder of the candidate for Tuesday to Wednesday. Instead of finishing at 3:30, we finish at 6 or 6:30. Can we get guidance on that? Honorable Breitenbach, Honorable Janji, in that order.
Thanks, Chair. Good morning, and good morning to everybody. Chair, for the debates, would it be possible for us to debate and leave? We don't have to stay for the entire sitting.
Yes, I think once we are done with our bills, but I'm sure, I think there's going to be another bill that will need to be voted on, which I think whips would insist that members would sit for that bill. I think there's something on transport.
But we can just log on for that. I mean, it could take.
Yeah, we can log on for that, yes.
Then I would suggest that we carry on Tuesday and get done, simply because it's a very long day then on Wednesday for the candidates, and it becomes unfair towards them. We've all experienced before the detriment attached to interviewing for long days. The candidates are tired by that time of the evening, but so are the members, and the interview that you conduct early in the morning and the last interview late at night differ significantly, which is not always fair. So I would prefer to then go to the House, debate, leave, log on if we have to vote, and carry on with them so that they're more equitably distributed across the 2 days. Thank you, Chair.
Thank you, Honorable Breitenbach. Honorable Janji.
Yes, Chair. Good morning, Chair, maybe, and everybody in the meeting. Maybe before I go further, just a clarity from your side. I might have missed this. Are we doing the interviews online or are we doing them physically?
Physical.
Okay. I support that, and therefore I also support the option that Honorable Breitenbach is proposing. I think that's efficient. We can log on and continue with our interviews because you will be there as a chair to deliver these bills upfront. So I think it's just a walk from there, and then we go back to the venue. I support that.
Yeah, thank you very much. Committee Secretary, can you organize that there is a separate room where we can log on and leave our gadget in that particular room? Because I've been made to understand that it's only the chairpersons and the whips of the ANC, I think the chairpersons that have offices, but everybody else still, they do not have offices. So it will be important that we have a room where we can, those who would not have access to their offices, where they can log on and leave their computers there when we are going back to the interviews. Can we take care of that?
Noted, Chair. Organize. Thank you.
Thank you very much. Then the second one, I propose that tomorrow, because we might finish early, that we also deal with the issue of the South African Human Rights Commission. It would be good that that complaint is disposed of before we go to the interviews the following week. Members were given the copies of the complaints and the response. Maybe what we might need to do is to furnish Advocate Mkhwebane with the copies, because I don't think that she was a member when that issue came before us. So it would be good that she receives the documents, both of the complainants and the response of the commission, so that tomorrow we can have a discussion and we dispose of the matter before we go to the interviews. Any objections to that?
No, Chair, it's fine.
Thank you very much.
Thanks, Chair. If they can also share the details of the candidates and those who
Yes.
for next week. Yes, thank you. Thank you so much.
Thank you very much. Yes, it's quite a long list. So I think Committee Secretary, if you can start now forwarding all that information to Advocate Mkhwebane.
Complaint has been sent already, Chair.
Okay. Thank you very much. Now we can proceed to the NPA amendment bill. How do you want to proceed? Will you start with the working document and then the A list, or would you want to do it differently?
Chair, I'm not sure who that's being directed to, but I think it's easier to work from the working document because the A list is just the amendments on their own. So it's difficult to follow them. But I don't know if Ms. Pillay agrees. She's got the working document up anyway.
Yes. Okay. Over to you, DM, and to your team. You will decide who is leading us.
Good morning, Honorable Chairperson, members and the Deputy Minister and officials online. Chairperson, I will take you through the working document, and if I experience challenges, then Mr. Sibele Micha will assist me. I hope I'm audible because I'm using two devices. So may I proceed?
Yes, you are very audible.
Okay, thank you, Chairperson. We have prepared the A list and the working document. And I think at the outset, Chairperson, let me point out that when I go through the working document, you will find that there are quite a few technical issues that we have corrected in the bill. There are some matters of substance which I will also refer to in presenting this document, but there are quite a few technical issues which we have taken from the comments that were made, but also in consultation and discussion with the law advisors from Parliament, which we are very grateful for their assistance so far in the matter, and it has assisted us to get this document together. So if I may proceed, in the long title, Chairperson, you will see there are some strike-throughs which relate to the way we worded the long title to clean it up and to make it more technically sound. We're proposing in the second line to delete the two, and because it's repetitive, and that has been pointed out to us by the law advisors, to provide for in the third line, to provide for the appointment of investigators, which is a repetition, and the word provide for or to provide for appears quite repetitively in the long title, and from a technical perspective, we are therefore proposing the changes which appear on the document. And under the transitional arrangements, we end to provide for transitional arrangements, and we propose deleting the rest up to the semicolon. And the last sentence in the long title would be, and to provide for matters connected therewith. Chairperson, I'm not sure if you would like me to slow down or you'll tell me when to stop, but in the absence of that, I will proceed to go to the...
I think members who would want to raise issues, they will just raise their hands. But if there are no hands, then we will proceed.
Thank you, Chairperson. Moving on to page 2, we have corrected the wording here. It's Parliament of the Republic of South Africa that enacts, not the old wording of be therefore enacted by Parliament. We have corrected that. There are no changes to the preamble. On the amendments, Chairperson, there's just a change to, this is just a technical change. It should appear in italics. We've corrected that. Subsection, clause 2A in subsection 1. The similar to reflect the head of the investigating directorate and the deletion of subparagraph B, the sub B in the reference to section 7.3. Under paragraph B, it's also a technical change in referring to investigating director in italics. The same goes for subparagraph C in italics, and the same for the subsection, the investigating directors against corruption. We've correctly reflected that in terms of drafting protocol. In paragraph clause D, subparagraph C, the investigator referred to in subsection 5(2)(f). And in this regard, Chairperson, it's again a technical change, but the original wording of the bill was quite confusing, and it has been pointed out that we needed to clean up the numbering, because if we refer to previously deleted portions and we brought them into the bill, it might lead to interpretation challenges, particularly if there was case law referring to these sections. And we've taken on board those comments on the drafting of that section, which we will go through later. The amendment of section 4 of Act 32 to merely delete the prosecuting authority comprises of the following members. Chairperson, after consulting with, I beg your pardon, Chairperson, just put my phone on silent. We have taken on board the comments that were received from the law advisors, and we believe that clause 3 is no longer necessary, and we propose its deletion. That is also technical, and from a drafting perspective, it does not necessarily relate to the interpretation. Clause 4 and the amendment to subsection 5. In this regard, Chairperson, as well, it is technical changes, and this is where we bring in the inclusion of investigators as members of the NPA would have been clause small d and a capital A. We have now made the necessary changes to delete the and to cater for it to be included under subparagraph F, which is much neater from a drafting perspective as well. On page 5, we had previously worded it as a substitution, but it should actually be an amendment. And in this regard, Chairperson, I must point out that not only are the changes here technical in nature, but it's also substantive. And in view of the changes, and in view of certain technical issues, we are now proposing that we delete the existing clause 5 and that we replace it with the following wording. So the changes on page 5 and 6 indicates the deletions on clause A and clause B. And I will go through the new wording now. So we propose the deletion of subsection 1, and we insert a new subsection 1A. There is hereby established in the Office of the National Director an investigating directorate to be known as the Investigating Directorate Against Corruption. We set out the mandate, which is to investigate and carry out functions incidental to investigations relating to serious, high-profile, or complex corruption, commercial or financial crime cases. So up to sub 1 to 3, there's no changes to the actual wording that is in the original bill. However, when we get to clause B, the committee will recall that there was a concern about the reference to Proclamation 19 of 2019, or is it Proclamation 20 of 2019? Let me just get the correct reference. Yes, it was Proclamation 20 of 2019. The concern was raised that we are making reference to a proclamation that will now be repealed, and that we should actually refer to what was in Proclamation 20 of 2019. So we have brought that in under subclause B to include additional related offences or categories of offences, including common law offences of fraud, forgery, uttering, theft, and any offence involving dishonesty. Clause C, additional related statutory offences or categories of statutory offences, including contraventions of Prevention and Combating of Corrupt Activities, Prevention of Organised Crime Act, the Protection of Constitutional Democracy Against Terrorist and Related Activities, Public Finance Management Act, the Local Government Municipal Finance Management Act, the Financial Intelligence Center Act, or any other statutory offence involving dishonesty. So, Chairperson, that brings in Proclamation 20 into the bill. So there is no confusion as to whether it no longer exists, etc. And it brings clarity to the mandate, because what is in Proclamation 20 is now to be interpreted as additional related statutory offences and not broadly the offences that we list in those in this clause. So it's not simply a broad offense of theft, for instance. It must be related to the overall mandate of the Investigating Directorate Against Corruption. Under Clause C, we include the provision where appropriate to institute criminal proceedings and carry out necessary functions. This is already in the bill. We've just repeated it because we are changing Clause 7. And we are inserting Clause 1B. This is from a technical perspective and drafting to clean up the drafting and to make the section read better. The President may, by proclamation in the Gazette, establish one or more additional investigating directorates in the Office of the National Director in respect of matters that exclude those contemplated in subsection 1A. And in this regard, Chairperson, we propose the deletion of subsection 2 of paragraph A, and we propose the substitution of subsection 2 of paragraph B, and we propose an amendment which says, shall be issued and may be amended or rescinded by the President on the recommendation of the Minister, the Cabinet member responsible for policing, and the National Director. And in subparagraph E, clause E, we include the insertion of investigators into this subparagraph. So those are the technical and the more substantial changes to the bill in this regard, Chairperson. There is one more substantial change to the bill, which I will get to. But on clause 6, we will have to, and we propose the amendment, the deletion of clauses. It will merely be shall in respect of any investigating directorate established in terms of section 7. So it's no longer necessary to have 1A or 1A small letter a. So I get to the last point, Chairperson, under the vetting of investigators. On 19E, we propose the deletion of the words as amended by the General Laws Amendment Act, because an amendment is taken to be read into the primary legislation, so it's not necessary to restate it. And on subclause 3, Chairperson, we propose the deletion of the existing clause and to replace it with the following clause, which talks to the powers of the National Director and whether the person must be discharged. And we needed to clean up this clause because during the comment phase, it was raised that it may not be in line. The original clause may not be in line with labor laws. So the clause will now read, if the certificate referred to in subsection 1 is withdrawn, the National Director, after consultation with the State Security Agency and subject to Section 2A(8) of the National Strategic Intelligence Act, may discharge the investigator concerned from the Investigating Directorate following any disciplinary process. So this attends to the issue related to the concern related to the application of labor laws, but also Section 2A sub 8 of the Strategic Intelligence Act relates to the process of appeal and review to the Minister of State Security when a certificate is withdrawn. So it is aligned to that act and aligned now, and in our view now aligned to labor relations. I think those are the changes, Chairperson, that we are proposing. Tsietsi, have I left out anything?
Yeah, thanks and good morning, Honorable Chair and Honorable Members. Just to indicate that as we're going through the documents, they're just minor things that we'll correct, like the paragraphing on one of the clauses. There was a repetition of B's and C's. We'll clean out, then we'll send the documents to the Secretary. Thank you.
Thank you. Let me also welcome the delegation of the MPA led by the NTPP, Advocate Shamila Batoy. You are welcome. Members, any comments? Honorable Breitenbach.
Thank you, Chair. Yeah, I'm sorry, I'm just moving to a different location because the city of Cape Town has decided to fix the potholes in my street and there's a noisy machine going here. Chair, I would suggest that the members, or certainly I do, need time to go through this document properly and consider these suggested amendments. Certainly, as the Democratic Alliance, we would like to make substantial inputs into this piece of legislation and see how they are going to be able to collate and dovetail with what is already here. We also have some serious concerns with certain of the clauses in this document, but in an effort to not be obstructive and in a sincere effort to accommodate what the NPA needs now on an urgent basis to move on, albeit temporarily, because this can only be a temporary solution. It certainly can't be seen as anything remotely satisfactory or sufficient to deal with the problem of corruption and organized crime. But as a stopgap piece of legislation, you know, sticking plaster over a gaping wound kind of thing, in an effort to accommodate that process, I would request that we be given time to properly consider this document now, and then be given time as soon as possible, but probably not before next week because of our busy program. A time where we can make inputs into this document for consideration. So that would be my request, Chair. Thank you.
Honorable Swart.
Good morning, Chair. Good morning, colleagues. Yes, I hold the same view that we need a bit of time to consider the document and its implications. I also firmly believe that the NPA needs this temporary measure. I would also like, with your permission, for the NPA to comment on these amendments so that we have a better understanding whether they are helpful. I think one of the main issues for me relates to the security of tenure, and I would like some more input from the department about the vetting process. I can understand there is a need, but is this applied for your average police investigator, that they need security vetting? I would just like to understand this process, and I'd like to hear from the NPA what impact the security vetting process will have on their existing investigators, whether it is something that is par for the course or whether this is a new measure that can have a negative impact. We from our side want to do everything to support the NPA in these very complex prosecutions, and we wouldn't like to see anything that impacts upon the security of tenure. So whilst we look, we need to study that 19E sub 3, which seems to be more helpful from a labor perspective regarding security of tenure, but the whole issue of vetting, and I apologize, Chair, I might have missed the discussions around this. If it is a broad consensus that it is necessary, then I accept that. But if this is a new requirement that is not required for your average police officer, then why is this a requirement for the investigative director? Thank you, Chair.
Sure. Are there any further hands?
Yes, Chairperson.
Honorable Mkhwebane.
Maybe I've raised a very dark hand, Chairperson. You don't see it.
Yeah. Yes.
Yeah.
My apologies for not seeing you. You
Yes.
are recognized.
Yes. Chairperson, I joined the portfolio committee late, and some of the questions and clarifications might be issues which have been raised in the past. The first question which I have is why this amendment? What do we intend to achieve? I'm asking this question because is corruption not a crime which can be prosecuted like any other crime? Yes, it's a very specialized field, but do we have to go all the way and amend the National Prosecution Act to legislate on that? Secondly, Chairperson, I've seen a number of provisions in this amendment bill, which actually it's very much operational, which should also then be dealt with. Maybe they need just to regulate them because of the fact that at least if it's regulated, then you are able to make sure that it's operationalized and some of the issues can be dealt with efficiently through the issue of standard operating procedures and service standards. Definitely, yes, you need a very credible investigator who's having security clearance and all those. The question is, do we have to put it in the legislation or do we have to then put it in the regulations? So I agree with Honorable Breitenbach on this one, that if also, because as well, joining late, I would need to just go through in details what is the reasoning behind this. And again, agreeing with the Honorable Swart on the issue that possibly the document, if it was submitted, I'll have to then be referred to it, where it details why the amendment, what are the benefits, what is it going to change? Because I think the critical issue for the National Prosecuting Authority and their independence, it would be for the EFF to have the NPA as one of the Chapter 9 institutions, which doesn't have any link to be falling within the Department of Justice. So that's the key issue, which for us is critical. But for now, I think I will also say, possibly if one would understand why this amendment and why some of the issues are not dealt with or regulated, and so that we can then remove a lot of operational which are cluttering this particular legislation. Thank you.
Thank you, Deputy Minister.
Thanks, Chair. Maybe just to respond to Honourable Mkhwebane, the reason for the bill is that there is an investigating directorate on corruption, so it's not creating anything new, but it is to make it statutory, so that, as Honourable Breitenbach keeps saying, it cannot be abolished by the stroke of a pen, because it was established by presidential proclamation, and it can therefore be abolished by a presidential proclamation. That's the first one. The second point is to enable the investigating directorate to employ its own investigators, which it can't do currently under the proclamation. And I think the issues in the bill are, many of them are similar provisions to what is in the amendment to the Police Act, which relates to the Hawks. So it's from that. There's obviously broader questions which Honourable Breitenbach referred to, of whether we should be having, I mean, what she wants, but we still haven't seen her bill, which was promised 2 years ago. But then I imagine the problem is the complexities of the prosecuting authority is given the power to prosecute. Should there be a separate Chapter 9, but that would require a constitutional amendment. And to some extent, we're waiting for the National Council on Corruption, Anti-Corruption's report early next year. So, Chair, just in a brief response to Honourable Mkhwebane. That's the reasons for the bill. Just then on, I think the officials can add around the vetting. My understanding is that there is provision for vetting of investigators, particularly for the Hawks, and it's a similar provision. But Chair, just then responding to Honourable Breitenbach's request, where she claims she's not being obstructionist, but effectively, Chair, the only real amendment that has been put before you, substantial amendment, is relating to 19E3. The rest is basically rewording, including the proclamation, or taking out reference to the proclamation, which Ms. Pillay explained, and putting those provisions into the bill. So I'm not sure what is new. This bill has been out for some time. I assume Honourable Breitenbach and her party had studied it. So I'm just a bit concerned. I mean, we do require this bill urgently. And we're hoping it could be passed by Parliament before the end of the year. That's both houses. So it will push it into the new year, at least with the NCOP. So just concerned with that, when in fact it's only really sub 3 that needs to be covered or considered. And it isn't just labour law, it is now giving the NDPP a discretion, may discharge, as to what to do, not must. So I'm just concerned about that proposal. But Chair, then I think if Ms. Pillay can respond on the issue of the investigators, and then to take up Mr. Swart's suggestion of hearing from the NPA. Thanks, Chair. And I don't think the NDPP is here. I think it's Deputy National Director Duplessis, Head of the Investigating Directorate, Andrea Johnson, and Dr. David Boughton, and then Dr. Florentia Belvedere, that are here. I hadn't seen the NDPP on the platform, but maybe she's joined on another device. Thanks, Chair.
Thank you very much. I will note the following hands: Honourable Horn, Honourable Breitenbach, Honourable Janche. But before they come in, let's allow Ms. Pillay to offer additional responses.
Thank you, Chairperson. I would just like to refer to our document on the summary of responses, but to refer to section 17E that deals with security screening and integrity measures in the South African Police Service Act 68 of 1995 as amended. 17E relates to the clauses on the establishment of the DPCI, and this relates the security screening and integrity measures relate to the investigators in the DPCI. So we have taken some of the information from there to develop the clause that is proposed in the NPA amendment bill. That is all I wish to add at this stage, Chairperson. Thank you.
Thank you. Honourable Horn.
Yeah, thank you, Chair. Let me at the outset say I want to add my voice to those colleagues who have asked that members of the Portfolio Committee be afforded at least 1 week, which is, of course, in the bigger scheme of things, not a long period, in order to study this last iteration of the bill as presented today. So there is some changes to the bill that the department has, of course, effected. And that, Chair, you assist members of this committee in order to give a proper effect to the right of members to ventilate all issues and to come with their proposals after having
a proper time to reflect on the current version of the bill, do a bit of further research, and in order for us to then deal with this in a responsible manner. I must say that in this regard, I strongly suggest that this committee must resist the pressure piled on us by the executive at this stage. I take note of what the Deputy Minister is saying about we need this to go, and I assume we is now the executive, to be processed by the National Assembly before the end of this year. But Chair, that can't be our consideration. We must give full effect to our processes. As the Honourable Breitenbach and others have indicated, there's some specific clauses which we must reflect on a bit further. From our side, we want to come with some proposals which could hopefully firm up this bill. And I'm saying this also, and not to politicize the matter, but whilst the Deputy Minister is quick to refer to both the Anti-Corruption Council and our intended private members bill and the fact that it's not been tabled, the long and the short is none of us are naive in dealing with this bill. We know that there's all probability that after this has been approved, this government will make a 180 degrees turn and say, this is now all of a sudden the response to the Zondo Commission report, which says this country must have a dedicated anti-corruption structure. And within that context, it would be absolutely irresponsible of us to now just rush through the processing of this bill just because the executive wants us to do that. Thank you, Chair.
Thank you, Honourable Breitenbach. Honourable Breitenbach.
Thank you, Chair. I'm largely covered by Honourable Horn, but let me just say this. The Deputy Minister does not determine the program of this committee, much as he tries. He's not the chair of this committee, much as he often tries to chair the committee. And I will not be told how to conduct the proper evaluation of legislation by the Deputy Minister. Thank you very much. If I want to be obstructionist, you've seen nothing yet. We're trying to make a sincere effort to accommodate the urgent needs of the National Prosecuting Authority in this arena, while trying to responsibly legislate, bearing in mind what the Honourable Horn said, that we've got no doubt that once this bill is passed, the government will take the view that this is now the end of the line and this is the masterpiece of legislation dealing with corruption. Well, I can tell you that it isn't. It is wholly insufficient, it is wholly inadequate, and it is wholly unsatisfactory. And no amount of panel beating will improve it. What we're trying to do is we're trying to accommodate the National Prosecuting Authority's very urgent needs for the moment. It can only be seen as a temporary solution. And we will have to, this committee will have to, and the members will have to, and the National Prosecuting Authority will have to, because Lord alone knows the department won't. We will have to sit down, we will have to draft a piece of legislation that properly takes care of this arena of large-scale corruption and organized crime in South Africa. If we do not, we're fighting a losing battle. If we do not strengthen the processes of the criminal justice system, the National Prosecuting Authority, and the way we approach crime in South Africa, this piece of legislation certainly doesn't do it. So all we're asking is 1 week to try and improve this piece of legislation to a degree where it can meet the requirements of everybody, where it will help the NPA on a temporary basis until we can come up with something much more permanent, something much more effective, something much more efficient. And I'll thank the ministers to stop trying to dictate to this committee. Thank you, Chair.
Thank you very much. Honourable Janche.
No, thank you, Chair. I will not be long, Chair. I just want to raise 2 quick issues. And I hope that because we're doing this as a committee and as our chair, that you would perhaps bear with us. I tend to support the request for an extra week for members who have asked for the purpose of trying to enrich the document in front of us. I don't see that as a train smash, that there's a request and then we just put in oogklappe and march on when we could be benefiting from that. And I raise this with your guidance, Chair, that because I know that it will kind of unsettle our program, but it does remain our program as a committee. So all of us will have to take responsibility for that if we agree to at least a week extension in terms of further comments. I certainly would want to ask the members, Honorable Hon, that let's not go to the 180 degrees kind of a phenomenon that you are raising. It doesn't exist here. There's no issue about that. I think that anticipation might not be helpful, and I'm not going to get into that kind of a discussion. So I'm only rising, Chair, so that we don't waste any further time. If it is possible that we can agree to the 1 week extension for more comments from members of the committee. Thank you, Chair.
Thank you, Honorable Janji. Honorable, maybe let me say, Honorable Maseko Tshela, Deputy Minister.
Thank you, Chair. Good morning, colleagues. I'm just rising to support the view that we give it a week, Chair, extra. Thank you.
Thank you, Honorable Tshela, Deputy Minister.
Thanks, Chair. No, the decision is obviously the committee's, and I just wanted to respond to Honourable Breitenbach's allegations or assertions that I'm trying to dictate to the committee. I'm raising an issue. It's for the committee to consider, and it seems that there is support for giving them more time. I was just pointing out that it's effectively only one clause that's being substantially amended, and the other responses, if the DA was interested in proceeding with the bill, the other responses could have been given already. But as with their private members' bill, which Honourable Breitenbach's colleague, Advocate Hoffman, has said is constitutional, which is great. I don't know if he's seen it. I haven't. That they could have brought that already. But if the committee wants more time, obviously that's the committee's decision. But I object to the allegations of I'm trying to take over the committee. I find that offensive. Thank you, Chair.
No, thank you very much, Deputy Minister. I think we will agree to the extension. Next week, Friday, will be the day we will deal with this bill. By that time, parties would have had enough time to do their research and make their inputs. So from today, the next time we deal with this bill will be on Friday. I think that is one issue. And then the second issue, I would appeal to members that please, I mean, let's, even when we disagree with one another, let us not put it in such a way that we take away another person's rights to have a different viewpoint. The fact that the Deputy Minister proposed or is of the view that the 1 week was not necessary or an extension was not necessary can't be construed as him trying to dictate to the committee, was just putting across his views, and of which members of the committee as a whole have got a different view. I think let us try and work in a way that we have been working. Everyone has got a right to a different view. Let us not attach anything other than that is a different view sponsored by that particular person or that particular member. So can we proceed with the understanding that we will discuss this matter on next week, Friday, because we know that on Thursday it's party days in the morning, and I think there's a sitting. Unless Committee Secretary, are you aware what we will be discussing in the House on Thursday? Maybe let's allow the Secretary to look at the program. Honorable Deputy Minister, Honorable Swart.
Chair, maybe Mr. Swart is going to say it, and I was reluctant to raise my hand in case Honorable Breitenbach accuses me of I see next Thursday, by the way, looking at my diary, is mini plenaries. Is mini plenaries. That's Thursday, the 16th. But I had just wanted, without at the risk of being accused of trying to take over the committee, but if I may politely point out that Honorable Swart had wanted to hear from the NPA.
Sorry, I just think that let us not go back to that.
Okay, but it was just that Honorable Swart had asked for the NPA's input, which you haven't given them yet.
Yes. Honorable Swart.
Yes, Chair, I'm covered. That's the issue I wanted to raise. We just wanted to hear from the NPA at this stage because it could help us in understanding if they've got any concerns about the amendments. Thank you, Chair.
Thank you. One, I would assume that NPA was part of the process of this bill up to the time that the bill was introduced to us by the executive. And I am wary of a situation where we would establish a precedent that we would not be able to sustain. Usually, this time is for members and the department, and we move from a premise that the department has done a thorough consultation with the relevant entity. I am generally not really do not support that, and I think that going forward it would mean that we would allow every other person who has had an opportunity to input into the bill. I think the Deputy Minister representing the ministry that also works with the NPA, and the NPA has been part of this particular bill. So I would suggest members that this interaction is between us and the department at this stage. Honorable Janje.
I fully support that, Chair. Thank you.
Thank you very much, Honorable Swart.
No, Chair. Well, then it's what is the point of the NPA sitting on the meeting? But then, can I just ask the department then that whether they have consulted the NPA on these newest amendments, and as far as they are concerned, that NPA is in agreement? Is that untoward to ask that? I'm just more interested in the new amendments. That's the point. But I presume that took place, Chair.
That's fair. The department, did you consult with the NPA on the new amendments?
If I can come in, Chairperson. Yes, we did consult with them. The clause on vetting was done in particular with the NPA. The submission came through yesterday. There's a slight change from what the NPA submitted on their mandate, but that is just a technical issue where they wanted the additional, if I can read that, Chairperson. They wanted when I say from a technical perspective, Chairperson, on clause 5, section to amend section 7, when we brought in the proclamation 20, it currently reads additional related offences or category offences, including common law offences. The NPA wanted the wording additional related offences or categories of offences, including but not limited to. And our view from a drafting perspective.
Really, what we are interested in is that was there a sufficient interaction between yourselves and the NPA?
Yes, Chairperson, there was.
Thank you very much.
Sorry, Chair, that's my understanding as well, from both the officials and the NPA themselves.
Yes, thank you very much. I think that is sufficient, members. I think that is sufficient. I think Honorable Swart would understand and agree. So can we agree that we will meet on Friday? I am wary of saying that because it's mini plenaries on Thursday, let's meet on Thursday, because you might find that in those mini plenaries, some of the discussion topics include peace and stability, which is our cluster. So members might be debating in those mini plenaries. So I think the safest one it will be to stick to Friday, that we would know that there is no sitting, and then we will proceed on the Thursday, on Friday. Is that fine, members?
That's fine.
Agreed.
Thank you very much. I think in the absence of any other item on the agenda, that brings us to the end of the meeting.
Thank you, Chair.
Thank you.
Thank you, Chair.
Recording stopped.